biodiversity offset sites are used in environmental impact assessments as a last resort tool for offsetting environmental impacts caused by development. This study will be focusing on the best practice method to ensure permanency of offset sites for the region of Queensland. By legalising conservation agreements between the proponent and the government, security of land can be established. Linkages will be made between Queensland's EIA processes in perpetuity of offset sites and our best practice. We will utilise information from global, Commonwealth and Queensland legislation and literature sources.
To secure an offset, they must be protected for the life of the impact. Therefore, to ensure permanency of protection, the offset site needs to be supported by legal mechanisms, in our case best practice, that ensure that the resources will be available to conserve and maintain biodiversity in the long term. Such best practices include legal security and protected area tenure. Legal security. Setting an offset site area under legally binding protection can guarantee permanence of the site. Legal security is therefore generally required for environmental offsets to enable the protection and management of a prescribed environmental matter contained on the offset site. Mechanisms to legally secure these areas are discussed under the relevant legislation. Land tenure. Land tenure is defined as how a party holds or occupies an area of land. Land tenure identifies who has the right to use and occupy land in the accordance with the various types of ownership.
Based on our research, Queensland's Environmental Offset Act is only one of few offset policies in Australia that is governed under the primary legislation. The Policy Act, which is highlighted in blue, is a whole of government policy for the assessment of offset proposals to satisfy offset conditions. This was just released in February this year. The policy is based on 7 principles, one of which is offsets are to be legally secured for the duration of the offset. It is also set on a number of guidelines, one of which is legally securing land-based offsets, and these are the ones we primarily focus on and reviewed.
Sustainability of offset measures is often enhanced by the introduction of legal mechanisms such as conservation agreements and conservation covenants. These are used in each state and territory to enable the protection of land that is set aside for environmental purposes on a permanent or long-term basis. Developers may be required to demonstrate the permanence of offset measures by securing land use rights at the offset site for the duration of the offset project. Conservation agreements can be used for implementing a range of management activities to benefit protected matter, such as fencing of important habitat areas. They can also require the landholder to refrain from, control, or refuse to permit activities that may adversely affect the species, ecological communities, or habitats covered by the agreement. In some situations, there may be difficulties in permanently securing a site for conservation purposes due to existing tenure of the land, which will be considered by the department on a case-by-case basis. Land tenure in Queensland. Land is generally referred to in 2 overarching categories as freehold land and non-freehold land or Crown land, which can be leased or licensed, which is also known as state land under the Land Act 1994. So the Land Act 1994 requires land administered under the Act to be managed for the benefit of the people of Queensland by having regard to 7 principles. These principles are sustainability, evaluation, development, community purpose, protection, consultation and administration. In addition, the provisions of other relevant legislation that may apply to an administrative decision under the Land Act must be considered. These example is Local Government Act 2009, Nature Conservation Act 1992 and the Contaminated Land Act 1991. The principles of land ownership are detailed in common law and have long been established in Australia. The systems of land tenure reflect the balance between both investor and community across a range of important areas such as natural resource, environmental and cultural management and sustainability.
The Offset Act requires an offset delivery plan for all proponent-driven offsets. One requirement for offset delivery plans is that it must state the measures that will be taken to secure the land on which the environmental offset will be undertaken. Once this plan is approved, the relevant party must enter into an agreement with the department. Future landowners are also bound by this agreement, and this is achieved by attaching the agreement to the land title. To ensure approval conditions are being met, the government agency mentions monitoring the offset site. However, it is not stipulated within the policy what exact steps will be taken to ensure appropriate monitoring is conducted. It also doesn't stipulate how breaches of conditions would be managed and what the consequences would be for proponents that violate the conditions of an agreement. One of the principles which underpin the Queensland offset policy is that offsets must be legally secured for the duration of the impact, but this only applies to significant residual impacts or where the loss is going to be permanent. So in other words,
offsets do not always have to be legally secured, which will ultimately result in some loss of biodiversity, and we consider this a limitation of the current framework. The Offset Act utilises many mechanisms to legally secure an offset, and these mechanisms are recorded in a register kept under the Offsets Act, as well as being noted on the title. The consent of all persons with an interest in the land is required to sign the declaration, and this legal requirement provides certainty in relation to the site being legally secured and does ensure permanence of offset sites. So we do see this as a very good practice within the Queensland EIA framework.
Queensland was well aligned with our best practice. It is well developed, robust, and on global terms significantly advanced. Overall, we found that Queensland's security of land agreements, processes, legal protections and enforcements to ensure permanency of offset sites are established to ensure land protection and thus conservation. Not aligned with our best practice is that Queensland's legal security is only required for sites where residual impacts are significant or where the associated loss are permanent, which is juxtaposed to our position as there would be no legal requirement to secure that land, and this could lead to a loss in environmental biodiversity.